Welcome to the virtual rebroadcast of PubCA's 2024 Government Contracts Annual Review. During this week, we are presenting 14 panel discussions featuring more than 70 expert practitioners, as well as 2 in-depth conversations with key government officials. PubCA publishes news and insights for the government contracts community, such as PubCA Protests and Claims, PubCA Cybersecurity and Data Privacy, and PubCA Compliance and Enforcement. In addition to our annual review, we also host webinars, podcasts, and in-person networking meetings during the year. If you'd like to learn more about PubCA, visit us online at pubcagroup.com. All of this week's presentations were recorded live at our in-person conference in February at the Ronald Reagan International Trade Center. You can join any or all of these sessions during the week using the same link and password you used today. All attendees will be in listen-only mode. Your video will remain disabled through the entire session. Many of our panelists are joining us today to answer questions about their presentations. Enter your question into the Q&A box at the bottom of your screen, and the panel will address as many as possible during the webinar. If time allows, we'll open up a live Q&A session after the video presentation. Our briefing book, which includes all of this week's slide presentations and other materials, are available for download from the PubCA website. We are applying for continuing legal education CLE approval in Virginia, California, Texas, Florida, Colorado, and Kansas. While we cannot guarantee approval, we expect acceptance within the next few weeks. We will notify all attendees when those approvals have been received. If you received CLEs for our in-person event, you can apply for additional CLEs for panels that you may have missed. And finally, if you are interested in obtaining CLE, please look for our poll question during the presentation. The state boards require us to verify your participation during the event. The poll is a simple yes/no question. We will keep track of all responses to verify that you viewed the panel. If you do not wish to obtain CLE credit, you can disregard the poll. This conference would not have been possible without the strong support of our event sponsors, all of whom are listed on the next few slides. Our sponsors also provided speakers for our event and other valuable input. We encourage you to review the strengths and capabilities of these firms and to reach out to them directly with any questions you may have. And now we present our next panel, Small Business Contracting.
Well, thanks everyone for getting your coffee and joining us early this morning for the Small Business Contracting panel. We've got an exciting presentation for you. My name is Matt Carter. I'm a partner at Pillsbury, and we've got Sarah.
Sarah Curtis, partner at Nichols Loop.
Steve Romali, partner at Miles and Stockbridge.
And good morning, I'm Matthew Schoonover. I'm partner at Schoonover and Moriarty in Kansas City. Go Chiefs.
Well, great. So we're going to start this morning's panel with an administrative, regulatory, and legislative update. And I'm going to kick us off with the discussion on the Department of Defense's new small business strategy that was launched early last year. And so as we all know, small businesses are vital to the American economy. But many people don't recognize that small businesses are also the backbone of the defense industrial base. In fact, more than 70% of the companies contracting with the Department of Defense are small businesses. But over the last decade, we've seen a more than 40% decline in small business participation within the DoD. And that shouldn't be surprising to anybody in this room with significantly increased regulation, complex regulations to boot. We've also seen fewer contracting opportunities for small businesses and significantly increased costs to work with the federal government. So to reverse this trend, the DoD issued this new strategy. And the aim here is to really simplify the process and make it easier for small businesses to work with the DoD. And the new strategy has 3 main initiatives. And the first initiative was the DoD established a small business integration group. And the goal here was to increase collaboration within the various DoD agencies to try to reduce confusion and reduce barriers to entry for small businesses. And we get calls from clients all the time saying, I'm really frustrated, I'm working with different branches of DoD, and sometimes it feels like the left hand isn't talking to the right hand. So the goal here really is to get the agencies in DoD talking to each other and to reduce that confusion and solve that issue to make things easier for small businesses to do business with DoD. The next initiative involved increased involvement of small business personnel and senior leaders at the early stages of the acquisition process. And the goal here was to ensure there was discussion between small business professionals and procurement officials to ensure that the procurement officials fully understand all the various capabilities that small businesses have to ensure that they have an increased amount of opportunities to contract with DoD. And then the final initiative in this strategy dealt with the recognition within DoD that many of our small businesses in the defense industrial base simply don't have the resources or tools to face some of the serious threats coming at the defense industrial base. And namely here, the focus is on providing tools and resources to small businesses to fight against cyber threats, in particular from our largest adversaries in Russia and China. And so I think the key takeaway here is that the DoD sees the value and importance of the small businesses in the defense industrial base, and they're taking actions to make it easier for small businesses to do work with DoD. Next, I'm going to talk about some new guidance that was issued on facility security clearances for small business joint ventures. Now, this new guidance really relates to some historical tension between the SBA and cognizant security agencies, particularly within the DoD. And so some history is important here. So historically, it had been difficult for small business joint ventures to compete in procurements where an offeror was required to hold a facility security clearance in its own name as a condition for award. And so the problem and challenge here was that small business joint ventures are required to be unpopulated. Many didn't have a facility security clearance in the joint venture's name, and thus those joint ventures were rendered ineligible for many awards. And this was true even if the individual members of the joint venture held security clearances on their own. So the SBA tried to address and rectify this issue a few years ago with a regulation, and that regulation prohibited agencies from requiring small business joint ventures to hold a facility security clearance as a condition for award. Now, despite that regulation and despite the fact that it derived in part from the National Defense Authorization Act, some DoD agencies took the position that the SBA didn't have the authority to tell the DoD what to do. They essentially said, you can't tell us what to do with something so important as it relates to security, in particular facility security clearances. This ultimately came to a head at the GAO, and the GAO sided in an opinion with the SBA, essentially affirmed the SBA regulation. But despite that opinion, there were still questions about whether DoD would continue to push back on that issue, whether DoD would issue new guidance or regulations that would revive the issue or create other new related issues as it related to facility security clearances. So after a couple of years of working together, the SBA and the Information Security Oversight Office issued this new guidance, essentially putting this issue to bed. And this new guidance says, consistent with the SBA's regulations, that a small business joint venture does not need to hold a facility security clearance in its own name, hold it itself, so long as the joint venture members hold the required clearance. Common sense makes sense, good rule. But the guidance does say a cognizant security agency may still require a small business joint venture to obtain a facility security clearance in its own name after award. So one thing to keep in mind here, even with this new guidance, is remain vigilant as you're reviewing RFPs and solicitations to ensure that there are no provisions that conflict with this new guidance, because if there are, You will need to get engaged with council as soon as possible to ensure that you challenge that provision before the due date for receipt of proposals to ensure that any challenge is timely and not deemed to be waived. And with that, I'm going to hand it over to Matt.
Yeah. We'll have a few updates on some socioeconomic programs for you today, and I get the joy of going first and discussing about some things that are happening in the HubZone program and some developments that we've seen and will see in 2024. And by way of background, the HubZone program is a small business socioeconomic program where if a small business has its principal office located within a HubZone and employs at least 35% of people who live in a HubZone, that business might be eligible for small business set-asides for HubZone companies. The point of the program is really to bring dollars into underutilized or underserved communities, kind of to help those communities develop economically. In SBA's regulations, the definition of employee, historically folks have usually focused on the number of hours that an individual needs to work for the company in order to qualify as an employee. You see it on the screen where it says that the person can be employed on a full-time, part-time, or other basis, really so long as they work a minimum of 40 hours over the preceding 4-week period. And that's not a typo, it's 40 hours essentially per month that person would have to work on behalf of the company in order to qualify as an employee under the HubZone regulations. Well, back in 2022, when SBA was going through some recertifications for HubZone companies, they by chance noticed a lot of commonality where individuals that would appear under one company as an employee were also listed under other companies as an employee. And it happened quite a bit. And so they became concerned, they being the SBA, became concerned that perhaps companies were placing individuals on their payroll simply to gain HubZone status, that these individuals weren't actually doing any work. Next slide, please. So in 2023, there was this debate in the HubZone community about what does that definition of employee mean? What does it mean to work? How important is that word in the definition? As I mentioned, a lot of the focus before was on the number of hours. And some businesses took the position that said, hey, so long as I'm paying somebody for 40 hours a month, what does it matter necessarily what they're doing for me? I'm a business owner, I can pay somebody to watch the wall not move all day. That's my choice as a business owner. SBA did not like that idea. They viewed the HubZone program as almost just as much of a job training program as it is a community economic development program. So in early March, we received some guidance from the SBA stating that an individual, in order to qualify as an employee, has to actually do legitimate work. SBA wants to know what that person's job description is, to know who is supervising them, to make sure that they are actually getting adequate training and adequate supervision to do the job that they're expected to do. And then in some cases, they'll actually review the work product that person has done in order to make sure that they are actually doing legitimate work on behalf of the company. And we see in the frequently asked questions that SBA released, they noted that it's their policy to preclude counting as employees for HubZone purposes these workers who are leased from a third-party business that's not a legitimate employee leasing concern. Essentially, they didn't want somebody farming out individuals just to appear on payrolls in order to gain HubZone eligibility. I will note, though, that is SBA's policy. and that's not necessarily reflected in the regulations as they currently exist. And I think SBA recognizes that. We're promised that we should get updated hub zone regulations sometime this year. I'd expect them to be sometime soon, quite frankly. But the SBA's new regulations should address this question more thoroughly of who qualifies as an employee for purposes of hub zone eligibility. One final thing on this, our friends at the Department of Justice, it may not surprise you, are involved in this question as well. There have been some indictments handed down to some individuals who were involved, I should say allegedly involved in these, what SBA would call a scheme to lease out some of these employees. So we'll kind of see how that plays out in this as well. But I would expect new hub zone regulations this year.
All right, so we're going to sort of switch gears and talk a little bit about some statutory developments. Obviously, Congress has a penchant for tinkering with the Small Business Regulations or Small Business Act, which then gets flowed into regulations. And this year's NDAA was no different. So last year, end of the year, President Biden signed into law, and it included 4 or 5 sections I wanted to highlight for you guys because they're pertinent to a lot of the stuff that at least Matt from Pillsbury, Matt Carter, already spoke about today. And they've left the Hub Zone program alone, thankfully. But you know, the regulations aren't complicated enough, so Congress wants to help us and make them more complicated. So the first is 853, which is the Procurement Technical Assistance Program. And this is really getting at what Matt was talking about earlier. This is facilitating education to cover, you know, the new, not really new anymore, but the safeguarding covered defense information requirements, and also mitigating risks related to FOCI. And here is, you know, it's a shared intent with DoD to essentially lessen burdens on small firms that have been complaining about these requirements for years. I think my personal editorializing around this is that, you know, Congress is getting at the educational component of this, but I don't think firms are having that kind of problem anymore. There are so many consulting groups around the country that can educate you on this. It is now a cost issue, mostly for small businesses, to try and implement these safeguards at a lower scale than the Lockheed and Northrops of the world that have the higher scale and thus can sort of apply those safeguards enterprise-wide with a lower per capita cost. So I don't think this does anything. This act doesn't do anything on the cost side. And I would expect Congress to maybe look at that in coming sessions, right? So moving on, 862 shortens the period for the prime to notify the KO when they are late paying a small business sub. So the rule used to be 90 days, but now it is going to be 30 days, or it is 30 days. Now, the stick here is that if they can't justify their late payment through some legitimate means or some legitimate reason, then there is authority for the KO to enter, you know, adverse past performance information into the CPARS system. It's a good stick generically, I think, but my commentary on this would be you are asking the KO to sort of get involved in the prime sub relationship, and that is, I think, inherently difficult and could spawn some claims around the justification for a CPAR where the prime thinks the sub was performing deficiently and thus withheld payment, and the sub disputes that fact. And now all of a sudden you've got like the ASPCA or some other Board of Contract Appeals having to opine on whether or not there was a breach of a subcontract, which to me sounds like a morass, but here we are. Next slide, please. So Section 863. This one's pretty straightforward. Just increases SDVOSB goals from 3 up to 5. Again, straightforward. 864. This one's a little interesting. It is phasing out the possibility for SDVOSBs to self-certify. Formerly, SBA had really focused on the prime programs because they thought certification was a little bit of a barrier to entry for, in particular SDVOSBs, guys getting out of the service, they want to form their own SDVOSB. What do they do first? Usually it's a subcontract, right? And so That's the entryway to the government marketplace. You typically wouldn't require certification for that. Congress, I think's perspective was there is still a lot of SDVOSB fraud at the sub-level, so we want to capture that and ensure that it, is vetted by SBA through the certification process. Like with the original SDVOSB certification change at SBA, when that moved from the VA to SBA, you're going to see a grandfathering process where, as long as folks they got their application in, they can still certify. But how that shakes out is, dependent on the way the regulation looks. So, next, I think, all right, so this is the last section of the NDA I wanted to highlight. This one I think has potential to be the biggest impact, or have one of the largest impacts, and I put it even though it's not necessarily a small business only thing, but it requires affiliates' past performance to be considered by DoD for small business bids on DoD contracts when relevant or if relevant. And so the DFARS has to be amended pretty quickly to implement this rule according to this act. And my view of this is it's, I think we all know this was a permissive thing that KOs have done from time to time, and there's some GAO case law on it about when affiliate past performance can be or must be credited. This definitely establishes the requirement as a mandatory one, but this caveat of if relevant, I think is potentially troublesome because it's a little vague. What does relevancy mean? Is relevancy mean if the technical requirements completed by the affiliate are relevant to the technical requirements being procured, or does relevant mean are those technical requirements similar? And also, the offeror has proposed the resources or assets of the affiliate to be performing on this current opportunity. I think you could take that latter position kind of reasonably, and that wouldn't actually change the case law too much because that's pretty much the way the current rule is. So I think we're going to need some case law around here to sort of suss that out and see how the courts end up interpreting this. But my expectations, I think this was intended to cast a wide net. Also, there's been some question over what's the definition of affiliate? Are we using the SBA rules or are we using FAR 2? And I think the answer there is it's probably going to be the FAR definition of affiliate, which is, I think, a little bit of I'd say it casts a wider net than the SBA rules does for that sense. So, moving on. Just quickly, ideas about what they might discuss this year. I've talked to House Counsel and Senate Counsel about this. I know these ideas are sort of moving through Congress. I don't know if any of them are actually going to become law. First is 8A sole source limit increases for non-tribally owned 8As. This has been a topic for years. $4.5 million is not a lot of money compared to 25 and $100 million for ANCs and the tribally owned concerns. So there's been some talk to move that up to 10 million. It has gotten very far within Congress and then failed at the last moment. So perhaps it will work this year. Rule of two stuff. I don't know if you guys are familiar with the Itility versus Tolliver debate that happened last year around the application of the rule of two. Recently, there was the executive order implementing an OMB memorandum attempting to apply Tolliver, essentially trying to establish a policy that Tolliver's correct. Tolliver held that it's a Court of Federal Claims case saying that the rule of two must be conducted prior to jumping inside of an IDIQ, which would have the effect of likely increasing the number of set-asides. And so SBA is moving that direction, and OMB has sanctioned that movement. Whether Congress tries to do it themselves is an open question as well, depending on how I think effective the OMB memo becomes policy-wise. And then I would also sort of put on your radar, there's likely to be some attention around small business subcontracting plan compliance. It's kind of the soup du jour right now because I think it's well known that there aren't a lot of enforcement mechanisms for subcontracting plan compliance.
So turning to some case law from the past year, we're going to start with Consolidated Safety Services v. U.S. Decision from Court of Federal Claims, who Stephen, I believe, was one of the counsel on this matter, so he can pipe in as needed. It was a NOAA case, National Oceanic Atmospheric Administration, Division of National Centers and Coastal Ocean Science. The fact dispute in this is what NAICS code got applied to the contract. It was a contract over $72 million. The contracting agency said we're going to apply environmental consulting services, 541-620, as opposed to an R&D NAICS code, which is what Consolidated would have preferred. They weren't going to be small under the consulting one, but they would be under the R&D. Judge Solomson kind of handed it to the agency and OHA in this case. Not only did he have a very painstaking review of what is research and development and how do you pick a NAICS code, applying all the appropriate standards, which I think we can all agree not many contracting agencies ardently adhere to. But they might now after this one. But the really crux of this case is really that the deference applied to OHA, typically given to OHA and to the agency, went away in this one, just because it was so unreasonable. It certainly rose to the level of arbitrary, capricious, and otherwise not in accordance with the law. They didn't look at their own precedent. Their own precedent was inconsistent. And Judge Solomson told them so very, very clearly in this one. So I'll keep it short, though, because of time, and we've got some other meatier stuff to get to you. Yeah, sorry, just kind of flip through those slides.
So now we're going on to SH Synergy. I'll try and be brief on this one, but I think everyone's probably heard of this case by now because of its impact for all GWACs. The part that wasn't really discussed was at least in my slides here, and I don't want to discuss it, is the aspect that they are now required on these sorts of GWACs to consider price at the GWAC level. So, as you may recall, Polaris originally did not have a price evaluation factor using something called the 876 authority, but in this case, the judge held that authority did not allow them to do that for fixed price contracts that contemplated fixed price task orders. That, however, is currently being fixed by Congress, so I think we might see that change in the future. The part that I wanted to talk about relates to the MPJV part, and this is a really strange and frustrating holding for a lot of us in this space because while I can't really criticize the judge's jurisprudential thinking here or reasoning, it definitely did not comport with, I think, what SBA intended the regulations to mean on this one. So what effectively, we can sort of skip to the next one. Thanks, Matt. The idea is that there is a rule out there in the SBA regulations that says that protégés cannot be held to the same standard as all offerors. Specifically, it says, a procuring activity may not require the protégé firm to individually meet the same evaluation or responsibility criteria as that required of other offerors generally. And this case talked about what that means. And there was essentially a requirement in this case for all offerors to have 3 prime past performance examples. And in the MPJV world, they only required the protégé of the MPJV to have 1. Right? So you would think at first glance that they've complied with the requirement, which is if all the primes have to have 3, but the MPJVs, among those, they only have to have 1 from the protégé, that's not the same as 3. 1 is less than 3, we're good. But the judge in this case really parsed the regulation and says they have to meet the same evaluation criteria. And the judge interpreted that to mean that the protégé, or may not require the protégé to meet the same evaluation criteria. The judge interpreted that as meaning, and we could skip to the next slide, please. That means that the agency can't even apply the same scoring rubric against the protégé as other prime offerors. And that caused the Polaris GSA office to take corrective action to essentially convert protégé experience into an option of a pass-fail versus a scored requirement. And I think I'm not going to get into the details of that because we don't have time for it today. That requirement effectively makes it much easier for protégés to bid, for very small protégés, for example, to bid on large GWACs like this, because now you can have other smalls or mentor past performance thrown in there in place of a lower scoring protégé experience requirement. And this is a challenging, I know this is a challenging decision for SBA OGC. I think SBA, I heard this, we all heard this at a recent ABA meeting, that John Klein is really thinking about significantly curtailing the involvement of MPJVs on GWACs. And I think we all saw this coming. It's kind of gotten to be a runaway train. I wouldn't necessarily blame the agency per se on it, but the case law that's come out around MPJVs has really made it almost so that the most recent GWAC awardees are predominantly MPJV, looking at T4NG, looking at COSP4. And so this is going to result in a pendulum correction, swing back. Don't know what that's going to look like yet. For now, Polaris looks like it's going to have a lot of NPJV awardees. And I'll leave it at that. Yeah, there you go.
Great. Well, keeping on the topic of small business joint ventures, so just by way of background, SBA's regulations allow a joint venture to qualify as a small business, a joint venture of two or more entities to qualify as a small business if two requirements are met. First, if the joint venturers meet individually the size requirements under the solicitation. And second of all, or have an approved mentor-protege agreement. And second, that the parties have a compliant joint venture agreement. SBA's regulations have really detailed requirements on what is required in a small business joint venture agreement, and SBA's case law at SBA's Office of Hearings and Appeals goes even further in expanding those requirements. And so really what we're seeing on the size standpoint and on the socioeconomic standpoint is really a parsing of joint venture agreements to make sure that they do meet the level of sufficiency that SBA's regulations require. And we've seen a few cases this last year that kind of clarify what some of those requirements are. The first case, and I won't necessarily talk about the background of the cases too much, just by virtue of time, and actually more to the point, I don't have it memorized. But SBA's regulations have had a rule that said a joint venture cannot bid on more than 3 contracts, or cannot win more than 3 contracts in a 2-year period measured by the date of the joint venture's first award. It's a really silly rule, but essentially it capped a joint venture for being a limited duration entity. I say it's a silly rule because in the next breath, the regulation says, well, to get around this, just create a new joint venture. And I've never seen any other regulation that prohibits something, but then also says, but here's how you get around it. In any event, that rule was a little difficult for small businesses to understand and comply with. So SBA changed it, I believe, in 2020 to make it more straightforward, that said, okay, we're just going to have a cap. Once that joint venture wins its first contract, it can't bid on any new opportunities more than 2 years after the date of the first award. Doesn't matter how many contracts that it wins in that period, just can't bid on any new after 2 years. This is an affiliation rule, so if you violate it, the joint venture partners are at risk of becoming affiliates with each other. And the Federal Performance Management Solutions case is a case that discusses this rule. And essentially the question there was, did the regulatory amendment reset the clock? Was it, when SBA passed that regulation, did everybody's 2-year clock start over? And the answer is no. The regulation is just updated. It's still 2 years from the date of your first award. That was still the point of the overarching, or the old evaluation, or excuse me, the old requirement under the regulations is to keep joint ventures limited. So the court in that case found that the 3 and 2 rule does not reset, and now it's just the in-2 rule, I guess. So next slide, please. We've also seen some questions about the level of management of the joint venture entity and the relationship of the parties in managing the joint venture entity. SBA's regulations say that the managing venture, that is the small business partner to the joint venture, in the case of a mentor-protege, or if, say, it's an 8A joint venture, the 8A partner to the joint venture, has to manage, be responsible for the joint venture's contract performance, but that other parties to the joint venture can participate in corporate governance activities as is commercially customary. Nobody really knew what that meant, and so there was some litigation to help define what that was. The case on the screen, Strategic Alliance Solutions, was actually an SDVOSB joint venture eligibility case, arguing that the operative joint venture agreement did not meet the SDVOSB joint venture regulations. Defense Integrated Solutions, the Court of Federal Claims case, you're looking at the loser. In that one, the issue there was essentially a joint venture operating agreement provision that said in order to bring a claim or litigation under the contract, both venturers had to agree. And so the question was, well, is that an area of contract performance where the managing venture has to have essentially full control, or is it an area of corporate governance over where both parties can control and that kind of veto power is appropriate? In that case, that is a matter of corporate governance. Is what Judge Solemson decided there. And so allowing all joint ventures to have a say is completely appropriate. I was on the losing side of this one, but I will note, I take this as a victory because SBA had to update its regulations to specifically allow for this. So if you're reading SBA's regulations now and you see, oh, well, it says in there, Matt, you're a dummy because it says in there that you can have a say over litigation. Aha! That's because I think we raised a very good argument. Next slide, please. Joint venture addenda, oftentimes in a joint venture agreement has to have contract-specific information or information relating to the solicitation that the joint ventures are going to bid on and how they're going to perform if they win that contract. So a lot of times what's pretty common, I think among most GovCon counsel, is there's almost like a master joint venture agreement between the parties and then a contract-specific addenda where when they identify an opportunity, they can fill in some of that information. The case on the screen, Focus Revision Partners, that was a very interesting procedural case. I was also involved in that one, was the winner, the actual winner. And this, I swear I'm not just raising cases that we were involved in. Essentially there, the joint venture, that case says that the joint venture agreement has to comply with the terms in the joint venture, the joint venture addendum has to comply with the terms that are stated in the joint venture agreement. So if your joint venture agreement says this agreement cannot be modified or can't have an addenda unless everybody signs that agreement, everybody needs to sign that joint venture addenda in order for it to be eligible. Kind of basic principles of contract law. It also must be in place, that addendum must be in place at the time the joint venture submits its bid. That's when the size of the joint venture entity is going to be determined. And so in order to qualify as a small business, you have to have a compliant joint venture agreement and addendum in place at the time you submit your bid. Next slide. Finally, attribution of joint venture receipts. This is an issue we continue to see pop up, and we did see an OHA case in 2023 give a little more clarity to what these requirements are. When determining a small business's size, that small business must include its proportionate share of joint venture receipts in its own size. And there's been some question about what is that proportionate share and how is that determined under SBA's regulations. And the OHA case on the screen, GC&V Construction, gave pretty detailed information as to how joint venture receipts should be proportioned when it comes to size attributions. And essentially it comes down to your ownership share of the joint venture. So you need to take a look at whatever and small businesses generally have to own at least 51% of the joint venture. So in that case, they're going to be attributed to at least 51% of the joint venture's receipts. But there you can also deduct any amounts that are already included in that small business joint venture member's tax returns. SBA has very limited exceptions to what goes into receipts, and I believe the OHA there said that that was, I think, an inter-affiliate transaction is how it counted in that. So the case on the screen gives very good, very helpful information for how joint venture members need to apportion their receipts for size calculations.
Great. We're going to switch gears now to talk about some recent developments with the SBA's 8A program. So a little background will be helpful here, and I'll try to be brief because I know we're running out of time. But for those of you who don't know, SBA's 8A program is a business development program that offers small disadvantaged businesses training and opportunities in the form of sole source awards and set-asides. And the program is generally limited to small businesses that are unconditionally owned and controlled by one or more socially or economically disadvantaged individuals. Now, under the regulations, there's a rebuttable presumption that individuals of certain ethnic or racial minority groups are presumed to be socially disadvantaged. And for example, those groups entail Hispanic Americans, Native Americans, Black Americans, amongst some others. And so that takes us to the Ultima case that was handed down last year from the Eastern District of Tennessee. And essentially, this court held that the SBA's rebuttable presumption was unconstitutional under the Fifth Amendment of the U.S. Constitution. In this case, Ultima was a small business owned and operated by a white woman. Ultima had successfully performed contracts for the USDA for many years. At some point in time, the USDA decided to move the contract for those services that Ultima had typically performed, move those to the 8A program, for which Ultima was ineligible. So Ultima filed a lawsuit in district court, and long story short, the judge agreed that the rebuttable presumption violated the U.S. Constitution. And so the important takeaway here is that the 8A program still remains open. It's in business. I won't get into all the details so we can get to our other slides, but the SBA's website provides a wealth of guidance for agencies, for current 8A participants, for potential 8A applicants. So if you're in the program or looking to get into the program, you can find all the information on the SBA's website and or talk to any of us after our discussion. But if you're in the 8A program, we just heard recently from the SBA that 300 current SBA 8A participants have had their eligibility suspended because they did not comply with this new guidance from SBA, which effectively requires anyone who relied on the rebuttable presumption to get into the 8A program to submit a new narrative, effectively new evidence documenting and demonstrating their social disadvantage. So that's the big takeaway here. And with that, I'll hand it over to Sarah.
And I'll just follow that up as well. On the Ultima, SBA in their guidance, along with Department of Justice, has only applied Ultima to individually owned entities as opposed to the entity owned. So ANCs and tribally owned are not facing that challenge yet. Turning to the next couple of cases, however, and we're going to take a sneak peek at what's coming. These were filed in 23, but late in the year, and are still in process, so we have no decisions yet, and I'm going to talk about them kind of together quickly because we are pretty much out of time. But Mid-America Milling Company and Bagshaw Trucking, they're two Indiana companies filing suit in the Eastern District of Kentucky, because that's where the events of the claim arise, allegedly. Their complaint, I will say, is fairly generic. It does attack the rebuttable presumption on equal protection grounds, so a constitutional challenge against the DOT's MBE program. That program's been around 40 years. It has faced many challenges thus far, has been continued to hold up so far. Based on the state of the complaint and the arguments of DOT, I'm not sure that I see them succeeding on this one. Could be wrong, but I don't see it making its way to argument. I think it'll probably get dismissed. But it'll be interesting to see. I think it'll actually be more entertaining maybe than the first, at least 3/4 of the Super Bowl last week. So that's the Mid-America case, but they should be having a hearing anytime, arguing their motions. They've got a preliminary injunction and a motion to dismiss at issue, and they're in reply stage, I believe. Advanced Simulation Technology v. U.S. is against an ANC, and it constitutionally challenges the rebuttable presumptions as they apply to ANCs. There's a footnote that sort of takes tribes out of it, but not entirely. So it's there. But I think the takeaway from both of these cases, and this is still in motion practice as well, filing I think was even due yesterday, but the takeaway from these is these challenges are not going to stop, right? Whether these are the cases that make it and are successful, the challenges to these programs are not going to stop, and one of them will be very ripe very, very soon. I think we'll see it within the next year or two, that one will make it to an oral argument, perhaps even the Supreme Court level. The programs may change significantly as a result, so be on the watch.
The last case we had up here, I'll try and be really quick. We're essentially out of time. This is a 180-day rule case at GAO. It just effectively emphasizes one really complex, thorny corner of the SBA regulations related to size recertifications and M&A activity. I think everyone knows when you get acquired as a small business or actually make an acquisition, you're required to recertify within 30 days. But what about pending bids? Well, a few years ago, SBA changed the rules to essentially say you had to recertify prior to award if you got acquired post-bid but pre-award. But what was the effect of that recertification? The regulation was silent. So then more recently, again a couple of years ago, SBA updated the regulation to say that if it's a small business set-aside and you recertify, you are therefore ineligible for the award. But that regulation was embedded in a whole bunch of other regs at 121.404G that effectively made it a little complicated when applied to task orders. So there's this one case, Odyssey Systems, from I believe 2021 or 2020, that held that it did not apply to a small business set-aside task under a OASIS SB Pool 1 set-aside task. Then this case involved the award of a BPA against the GSA schedule, and likewise, GAO held that the 180-day rule did not apply for some various technical reasons. The reason I highlight this case is that in response to actually Odyssey, while this case was pending, SBA updated the regulations to more explicitly apply to orders. But the takeaway here is we're not sure that the way they did it actually effectively made the rule applicable to orders because it's still a little complicated. This is all to say, talk to your legal counsel, and I'm not even sure we're going to be able to tell you what the rule is, but it's very complicated and it likely depends significantly on your specific circumstances. So I'll leave it there.
I think that's all we have. Thanks for your attendance today. If anybody has any questions.
Thank you for attending today. We have one of our panelists, Stephen Ramilly, available to answer questions. If you have any questions, please enter them in the Q&A box down at the bottom. I'll turn it over to Stephen.
Hey guys, hope everyone's doing well. Happy to address any questions, if there are any.
And Stephen, if as we wait for questions, if there are any, is there anything more you'd like to add to that presentation?
You know, that was a pretty fast and furious summary of a lot of pretty higher level, I would say, detail-oriented changes. The outcomes of a lot of these things need to go through the courts before you even understand what half of them mean, which I think I was emphasizing there in that last segment. So, you know, things that we didn't cover on that presentation sort of include some of the more, even more detailed and esoteric case law updates, which I'm happy to address because I have a general working knowledge of the cases in this space. But, you know, without prompt, I don't really know what anyone wants me to talk about, so I'll probably leave it here. I don't need to waste everyone's time. We can get back to everybody's Monday, if that's indeed the case. So we got one question. More about agencies doing a better job of identifying NAICS codes. COs want to do a good job. Well, so I was protesters counsel in Consolidated Safety Services, and so I was the one who vanquished, in this case, the Department of Commerce's NOAA. I have seen this as a really big problem historically. Most times KOs go with whatever they have done historically for a particular set aside, and just because you've done it in the past doesn't mean it's the correct code, because there are only very certain circumstances where a contractor would want to challenge a code. And the case that I had involved those specific circumstances, right? And let's see, the crux of the decision based around what is the best code, and that the code that best reflects the effort to be performed under the resulting contract. And there aren't a lot of parts of the FAR or the SBA regulations for that matter that focus on some sort of best sort of teleological choice, so to speak, to use a philosophical concept. The idea that you have to actually not just choose a reasonable code, but you have to reasonably choose the best code. So the standard for this, and Judge Solemson really honed in on this aspect of the regulation, the standard for NAICS code selection is a little bit higher. It's easier to show that the choice was arbitrary and capricious because the contracting officer is supposed to choose the best code, right? So when, I don't know if I'm sure there's a lot of agency counsel on this phone, whenever you are advising your KOs, it is not the typical, you don't have to be right, you have to be reasonable advice. It is you need to be able to defend the fact that you've chosen this code and that this code is better than any other code that exists. So what does that mean? I mean, best code in our case came down to, remember, the judge didn't actually select a code in that case. The judge just acknowledged that the agency could not defend their selection of a code, right? And one of the questions that arose at trial when I was, standing before the judge was he was asking us, is there economic data? Is part of the IGCE a statement of whether the procurement was majority consulting or majority research and development? And that was, I think, a difficult thing for the agency to answer, because actually there is no such research conducted in IGCE analysis, right? It's all, we think the total price is going to be this, but the agency isn't like bucketing different types of work. And I think that might be the direction. If you want to defend a NAICS code, that's the direction the agency is going to have to go. I think there's, or could go. I think there are less things you could do as long as you said, hey, at least some percentage of work, at least, hours at least, are one thing versus the other. I mean, in our case, my client was measuring oyster beds growth effectively. That was like the predominant nature of the work. Like, it was laughable that the agency thought that was consulting, right? And they couldn't, I mean, there were like some consulting tasks. Certainly you had to like advise the agency on what to do about, oyster beds that aren't growing properly, right? So that's kind of, that's why we won that case so handily and so easily, because it was such a preposterous thing for the agency to take a position on. But in the process of that, we led to this, outcome that was much more, I would say, instructive, because Judge Solemson wanted to sort of teach everyone how to do this. So, I mean, I guess the best answer to your question, guys, is you read the opinion. It's a pretty good instructive case. So. Yeah. Look, I could talk about that case forever, but I think I'll leave it there. Thanks, guys. Anyone else?
Well, if there's no other questions, we can call it a day and let everyone get on with it. Thank you very much to everyone. Thank you again to Stephen. And please stay tuned for our next session.
Cheers, guys.
Thank you for joining us today. And thank you to our panelists for their presentations and live Q&A. And again, special thanks to our sponsors whose support made this event possible.